Hi, I'm Elizabeth G. of the G Law Firm, and today I wanted to address a topic that isn't addressed as much as it should, but it's very important. The issue is what happens if I'm in a dependent status and my family relationship with the primary applicant changes? What I mean by a change in the family relationship is sometimes the relationship can end in divorce, or sometimes the relationship can end in death of the primary applicant. More often than not, we are primarily focused on the principal applicant. So for example, in the case of an H-1B non-immigrant visa worker, we're focusing all of our attention on the H-1B, their relationship to their employer, and as well as their ability to work for that employer on this visa. And then the derivative status of their spouses and their children are sometimes an afterthought. And the reality is that life happens. And life can happen in such a way where the relationship may end in divorce, or God forbid that something happens to the primary applicant and he or she predeceases. So the question is, then what happens to me? What happens to me as an H4? What happens to my children? Look, I'm just going to be very blunt with you. The reality is the immigration laws are unforgiving in these types of circumstances. So it means the moment the family relationship ends, so does your dependent status, regardless of what the paperwork says. So there's no grace period. There's no time afforded to you to settle your affairs. Depending on whether your I-94 card is expired or will be expiring, the only difference may be that you may or may not be accruing unlawful presence. Now, that's another topic for another video. But the important thing here is that you need to have a plan just in case this happens so that you can exercise your options. So in the case of divorce, you already know it's happening. And you're probably going to have a court date or an appearance at the court that will give you a definitive date as to when the divorce will be finalized. And if you're working under the assumption that your derivative status will end parallel to that date, you need to have your affairs in order to plan for a change of status to another status, temporarily to a B2 status, for example, so that you have time to settle your affairs. Or if you had plans all along to study or to engage in employment, you need to have explored those options at that time, ideally, even before that time. Now, in the case of a sudden death, this is a little bit more difficult because there's no plan. There's no warning that this is going to happen. But still, hiring an experienced immigration professional will give you options or a roadmap to where you need to be and where you could be so that you're not wasting valuable time as time ticks towards the accrual of unlawful presence. And finally, sometimes the best option is the simplest one. You just have to leave. You have to leave so that you can start over. Remember that if you don't have any violation in your non-immigrant visa status, you can always explore options while outside the United States and plan your return to the US as soon as possible. And today I want to leave with you with a tip that I gained while working on immigration cases for a large tech company. If the employer offers you the opportunity to gain your own non-immigrant visa status, take it. Say yes. And the reason is, even if your husband, for example, has an H-1B and you're perfectly fine working on the H-4 EAD, what happens when he loses the H-1B status? If you guys are still together, you can serve as a backup, transfer his status as your derivative, or if you're not together, you can stand on your own 2 feet and have your own status so that you have more options about your future. So as you can see, life can be messy, but your immigration status and your immigration case doesn't have to. Give us a call and schedule a consultation so we can talk about options that work for you.